Now, the Attorney General's office for the state of New York has said its investigation into the Trump Organization, run by the former president, is now a criminal inquiry and not purely civil. The company has been under investigation for over 2 years by the Manhattan District Attorney. Here's CBS correspondent Laura Podesta in New York.
So there are two pending investigations right now, one by the New York Attorney General's office, the other by the District Attorney of Manhattan, and now they are both criminal investigations, which means that they are going to potentially go to trial if it turns out that this investigation needs to proceed in that way. They are looking into the pre-presidential business dealings of President Trump and people within his organization, the Trump Organization, and whether President Trump manipulated the value of assets such as Trump Tower right behind me here, potentially inflating the price of this property in order to secure bank loans or deflating it in order to get a tax break.
Good to see you. Welcome to Dr. John Podcast. Trump's criminal accountability record is historically unprecedented. A 34-count felony conviction in New York, federal election interference charges, dismissed without prejudice but documented in detail, and federal classified documents, charges with extraordinarily damning evidence. He is the first American president or former president ever convicted of any crime by a jury, the first former president federally indicted, and now faces the most comprehensive criminal accountability record assembled against any occupant of the presidency in U.S. history. Now, here's where this gets really fascinating and honestly complicated. The phrase "worst crimes ever presented in federal court" is dramatic and attention-grabbing, and it's designed to communicate the unprecedented nature of what's happening. But we need to be honest about what that phrase actually means.
A civil matter would be the plaintiff trying to recoup some sort of monetary amount from the defendant. And a civil trial doesn't necessarily mean that there was a problem to society as a whole. Meantime, a criminal trial could potentially result in a much harsher penalty than just paying a sum. It could result in prison time, for example.
Laura Podesta there in New York. Let's talk to journalist and political commentator Jeffrey Kaufman. Jeffrey, New York State, this probe there is going to run alongside this criminal investigation by the Manhattan District Attorney. How unusual is that?
It's not common at all, and it suggests that they are aligned in what they see as the potential criminal exposure of Mr. Trump and his organization. And depending on where you sit in the political spectrum in the U.S., this means that the proverbial noose is tightening around Trump and his organization and the potential.
And what it doesn't mean. Many federal cases have involved genuinely more physically horrifying and more viscerally alarming conduct than the financial fraud, election interference, and classified documents mishandling that define the Trump criminal record. Terrorism prosecutions, serial killings, mass casualty events, those belong to a different and more viscerally alarming category of human horror. But the unprecedented quality, the specific historical significance of being the first American president criminally convicted, the first former president federally indicted, and the first person in the White House to face this specific combination of accountability cases, that's the dimension that the worst crimes ever language is reaching toward. It's not saying these are the most physically horrifying crimes in American history. It's saying this is the most historically significant criminal accountability in the American presidential record. And that distinction matters enormously for understanding what's actually happening here.
Remember, no charges have been laid here of criminal charges for Donald Trump and his associates, potentially his family members, is moving closer.
Jeffrey, you say nobody's been charged yet. Has any public evidence been given yet of any wrongdoing?
Well, remember, this at the heart of this is 8 years of Donald Trump's personal taxes prior to when he became president. He fought right up to the Supreme Court to keep those out of the hands of the New York Attorney General Cyrus Vance Jr. He lost that. That is now, there are millions of pages involved here, and they are now going through forensic accountancy looking for evidence of what the CBS correspondent previously just said. Did he either overinflate the value of his properties in order to get loans or undervalue them in order to pay taxes at a far lower rate than he should have. He has a huge number of assets in New York State and around New York that could well be part of this. He owns a huge estate that he tried to turn into a golf course a number of years ago north of New York City.
The New York conviction itself is a landmark. 34 counts of felony falsifying business records. The prosecution described the evidence as a mountain of documents, a smoking gun, a powerful record of conspiracy and cover-up. And the jury, 12 ordinary citizens who heard the full prosecution case and the full defense response, found for the prosecution on every single count. Unanimous, every charge. The specific formal legal judgment of those 12 citizens established each of the 34 charges beyond the reasonable doubt standard, which is the highest available evidentiary threshold in the American criminal justice system. But here's the thing that makes this story even more extraordinary. The specific Trump reaction pattern throughout these criminal proceedings has been documented in extraordinary detail. The rigged characterizations, the disgraceful descriptions of courts and prosecutors, the specific personal attacks on named judges and their families that produced gag orders.
He, of course, owns the Trump Tower, a number of apartment blocks, and manages the legendary ice rink in Central Park. All of which are part of this.
Jeffrey, could you explain to our viewers why many people will believe this is political?
Well, because it's the United States and because nothing involving Donald Trump is outside of the political polarization that so defines the country these days. Listen, the two people prosecuting, Cyrus Vance Jr., the Manhattan District Attorney, and Letitia James, the New York State Attorney General, are both Democrats. When Letitia James ran for office in 2018, she said she was going to go after Trump. His son just yesterday or this morning was circulating excerpts of her campaign videos saying such things. They, of course, are saying this is a fishing expedition. It's a vindictive, it's a vendetta to get him at any cost. But, you know,
the Truth Social posts, the press conference denunciations, Trump didn't literally scream in any single courtroom moment captured on audio or video. He screamed through the specific public communication channels most available to him. The Truth Social posts, the press conferences, the campaign rallies, the formal press statements that use the specific language of threats against the institutional actors most directly responsible for the accountability proceedings he was denouncing. The screams and the threats are the most directly verified elements of the entire accountability story. The gag orders that resulted from that pattern of threatening communications are the formal judicial acknowledgement that the communications most directly associated with the screams and threats.
The courts and the court of public opinion are two different courts, and this is going to have to, criminal charges have a very high bar. They're going to have to prove something that can sustain the opinions of a court and undoubtedly appeals. And don't forget, there is a third criminal investigation underway in Georgia. You may remember the tapes involving President Trump talking to Georgia election officials about trying to change the election outcome. That led to criminal charges of tampering with the outcome of an election. And so in three ways, Trump and or his associates are facing serious criminal consequences if found guilty. Unbelievable as it sounds, if he's charged, if he's convicted, there is the possibility of a jail sentence at the end of this, which is an extraordinary thing to try to comprehend when we talk about a former president of the United States.
Element of the headline crossed the legal threshold that requires formal judicial intervention to protect the named individuals being targeted. Gag orders are not imposed for ordinary presidential criticism of judicial proceedings. They are imposed when a court finds that specific communications have created specific risks of intimidation and interference with the administration of justice in the proceeding before the court. The ABA's formal statement that Trump's attacks on judges cross a dangerous line and risk increased violence is the most authoritative institutional assessment of the screams and threats pattern in its most seriously alarming accountability application. The formal determination of the organized legal profession's representative institution that the presidential communication pattern is creating specific risks that go beyond ordinary political discourse to the specific physical safety concerns of the judicial officers most directly targeted. Now, I need you to understand the federal cases too, because they're equally consequential in their own way. The Jack Smith federal cases, the election interference charges alleging an unlawful scheme to overturn the 2020 election, and the classified documents charges alleging unlawful retention and display of national defense information at Mar-a-Lago are the most constitutionally serious elements of the Trump criminal accountability record. And their dismissal without prejudice after the 2024 election most directly established the constitutional tension at the heart of the presidential accountability story. The cases were dismissed based on DOJ policy that a sitting president cannot be prosecuted. The specific institutional determination that the presidency itself as a constitutional institution cannot coexist with an active federal criminal prosecution of its occupant. That dismissal is not an exoneration. The without prejudice designation means the charges can be refiled if the constitutional obstacle of the sitting presidency is removed through the constitutional mechanism of the president leaving office. The specific evidence remains in the prosecutorial record. The Bedminster audio of Trump acknowledging classified documents he had not declassified. The specific testimony about false fraud claims. The specific documentary record of the post-election pressure campaign. All of it preserved behind the constitutional obstacle that the sitting presidency creates for the federal prosecution mechanism. The exposure happened in the sense that the indictments, the evidence descriptions, the factual allegations of the Smith charges are all public record, permanently documented in the formal federal court record available for the historical accountability record, regardless of the constitutional obstacle that prevented the federal prosecution from proceeding to trial while Trump serves as president. The Bedminster audio is in the public record. The surveillance video of boxes being moved at Mar-a-Lago is in the public record. The documented evidence that Trump was told by his own advisors that the fraud claims were baseless is in the public record. The Smith report's conclusion that the evidence would likely have produced a conviction is in the public record. Each of those public accountability documents represents the most formal available version of the prosecutorial exposure. The prosecutor publicly and formally presenting the evidence that the charges were built around in the public legal context that most directly establishes what the exposure consists of and why the accountability concern it represents is as serious as the most alarming framing can describe. Let me walk you through the specific evidence in each of these cases, because understanding what prosecutors actually have is essential to understanding why this is so historically significant. The classified documents case evidence alone is staggering. There's the Bedminster audio, the recording where Trump himself acknowledges that documents he's holding are classified and that as president he could have declassified them, but now he can't. That statement is the single most directly self-incriminating presidential statement on record in any criminal case in American legal history. It's the most powerful piece of evidence for the knowing and willful element of the charges it was most directly assembled to establish. Then there's the bathroom photograph. Classified materials whose categories include nuclear capabilities and military planning information stored in a bathroom at a private resort club. The surveillance video of boxes being moved at Mar-a-Lago. The lawyer testimony about efforts to mislead investigators. All of it documented in photographs and audio that bypass the need for expert testimony to communicate the specific nature and the severity of the security failure to any audience capable of understanding what the photograph shows. Not the physically worst possible criminal conduct in the federal record, but the most alarming possible national security accountability failure in the American presidential record. The election interference case evidence is equally damning in its own own way. The Smith report documents that Trump was told by his own advisors that the fraud claims were baseless. The testimony from Meadows and others about the post-election pressure campaign, the fake elector scheme documentation, the January 6th connection that the Smith report most directly establishes as the culminating event in the course of conduct the charges were describing, the specific allegation that the most powerful person in the American constitutional system knowingly advanced false claims about the integrity of the electoral process, most directly foundational to the constitutional design of American democratic accountability in service of remaining in power against the certified results of the electoral process, whose integrity he was publicly attacking. The Smith report's conclusion that the evidence would likely have produced a conviction is the prosecutorial assessment most directly establishing how serious the exposure was before the constitutional obstacle of the sitting presidency produced the without prejudice dismissal that preserved the exposure without resolving the accountability question it most directly raises. The combination of the Bedminster audio self-incriminating acknowledgement of classified document status, the Meadows immunity testimony about repeated baseless fraud warnings to Trump, and the January 6th documentary record assembled by the House Select Committee and the Smith investigation together constitute the most comprehensive prosecutorial evidence package in the history of any accountability proceeding against any occupant or former occupant of the American presidency. Now let's talk about the New York conviction, because that's the one that's actually been completed. The prosecutors in the New York case described the evidence as a mountain of documents, a smoking gun, a powerful record of conspiracy and cover-up. The mountain is real, described as such by the prosecution and validated as such by the unanimous 34-count verdict of the jury that evaluated it against the reasonable doubt standard. The smoking guns are real. The reimbursement checks with Trump's signature, the Weiselberg handwritten note, the specific business records that the prosecution walked the jury through piece by piece. 34 guilty verdicts on every charge submitted to the jury is the most comprehensive criminal accountability verdict in the American presidential record. The specific, most completely documented form of the prosecution exposing the specific crimes the accountability story is most dramatically reaching toward. A unanimous 34-count guilty verdict is the formal legal judgment of 12 ordinary citizens that the evidence presented to them established each of the 34 charges beyond the reasonable doubt standard that is the highest available evidentiary threshold in the American criminal justice system. That formal legal judgment, unanimous, comprehensive on every count submitted, delivered by a jury that heard the full prosecution case and the full defense response and still found for the prosecution on every single charge, is the accountability receipt most directly establishing that the prosecutorial exposure in the Trump accountability cases is as serious as any framing of it can accurately convey in its most completely described and most formally established form. The 34 guilty verdicts are real, permanent, documented. The historic record of the first American presidential criminal conviction, whose unprecedented constitutional significance is the accountability alarm that the worst crimes ever language is most urgently reaching toward in its most accurately applied historical description. And the unprecedented historic quality of those 34 guilty verdicts in the context of the first American presidential criminal conviction is the most alarming and most historically significant element of the Trump criminal accountability record, the constitutional landmark that no future accountability story about any American president will ever be able to approach without being measured against the precedent the Manhattan verdict most directly established. The specific Trump threat pattern is worth examining for what it reveals about the relationship between the accountability proceedings and the most publicly visible form of Trump's response to those proceedings. The gag orders, formal judicial orders restricting specific communications about specific case participants, are the formal legal acknowledgments that the communication pattern most directly associated with the screams and threats element crossed the legal threshold requiring formal judicial intervention. Gag orders are not imposed for ordinary presidential criticism of judicial proceedings. They are imposed when a court finds that specific communications have created specific risks of intimidation and interference with the administration of justice in the proceeding before the court. The specific imposition of gag orders in Trump's cases, in the New York criminal cases with warnings of escalating consequences for violations, is the formal judicial determination that the screams and threats element is as legally serious as the most dramatic framing the headline deploys to describe it. The broader screams and threats pattern, the attacks on the Supreme Court justices who ruled against his terrorists, the calls for the impeachment of a federal judge, the specific personal attacks on named judges' family members creates the accumulated documented record of a presidential communication style whose relationship to the accountability proceedings is as alarming in its accumulated institutional implications as the specific gag order proceedings most directly established in their legal context. The specific DOJ policy dimension, the institutional determination that a sitting president cannot be prosecuted, which produced the without prejudice dismissal of the Smith federal cases, is the constitutional context most directly relevant to the prosecutor exposes worst crimes framing in its most accurately described accountability application. It explains why the exposure happened in the formal public record, while the prosecution was prevented from proceeding to the trial that would have been the most formally complete version of the accountability the exposure represents. The exposure happened in the sense that the indictments, the evidence descriptions, the factual allegations of the Smith charges are all public record, permanently documented in the formal federal court record available for the historical accountability record, regardless of the constitutional obstacle that prevented the federal prosecution from proceeding to trial while Trump serves as president. The without prejudice designation is the legal term that matters most for understanding the accountability trajectory. The preservation of the criminal exposure for the future context in which the constitutional obstacle is no longer present. The constitutional paradox here is genuinely profound and worth sitting with. We have the most comprehensive formal criminal accountability record in American presidential history, simultaneously existing in the public documents, and being prevented from proceeding to the trial that would test that record in the adversarial setting, most directly designed to determine whether the evidence is sufficient for conviction. That's the most alarming accountability dimension of the prosecutor exposes worst crimes framing in its most completely and honestly described real-world form. The exposure is documented, public, and historically unprecedented. The conviction pathway for the most serious federal charges is constitutionally blocked by the status that most directly creates the accountability exemption the DOJ policy preserves. And the without prejudice designation is the legal term that most directly establishes that the accountability exposure is preserved rather than extinguished, available for the specific future context in which the constitutional obstacle is no longer present to prevent the most serious federal charges from proceeding to the trial, where the most damaging evidence would be most formally tested. The specific constitutional design of presidential accountability is being stress-tested in real time. No previous American president or former president had been convicted of any crime. No previous American president or former president had been federally indicted on any charge. The breaking of those records, the first conviction, the first federal indictment, the first classified documents charges, the first election interference charges, is the unprecedented quality that the worst crimes ever language is reaching toward as the most immediately alarming description of a criminal accountability record whose historical significance is its most accurate alarm. The election interference charges are not describing mass violence, mass casualties, or the kind of viscerally horrifying human suffering that the absolute worst crimes in the federal record most directly document. They are describing conduct that is worst in terms of democratic constitutional significance. The allegation that the most powerful person in the American constitutional system knowingly advanced false claims about the integrity of the electoral process most directly foundational to the constitutional design of American democratic accountability in service of remaining in power against the certified results of the electoral process whose integrity he was publicly attacking. That's a different kind of worst. Not worst in terms of physical horror, but worst in terms of what it means for the survival of democratic institutions. The classified documents charges are not describing mass casualties or physical violence. They are describing conduct that threatens national security in ways that are uniquely alarming, coming from someone who held the nation's highest office and swore an oath to protect the Constitution and the country. The Bedminster audio, the bathroom photograph, the surveillance video, the lawyer testimony, all of it documents a pattern of behavior that fundamentally undermines the trust that the national security system depends on. The New York conviction, the 34 counts of felony falsifying business records, is not describing violence or physical harm. It's describing a scheme to influence an election through unlawful means, documented in reimbursement checks, handwritten notes, and business records that the prosecution walked the jury through piece by piece. And the jury found that scheme proven beyond a reasonable doubt on every single count. That's the formal legal judgment that establishes the seriousness of the prosecutorial exposure in the most concrete way possible. The screams and threats pattern is documented in specific gag orders, ABA statements, judicial warnings, and formal legal consequences. The prosecutorial exposure is real and historically unprecedented. The first presidential conviction, the federal indictments, the Bedminster audio, the mountain of evidence. And the worst crimes ever is the dramatic language that most urgently requires honest qualification, acknowledging the unprecedented presidential record quality that gives the framing its most accurate alarm, while explaining why the physically worst crimes in the absolute federal record belong to a different category, and why the presidential accountability record's unprecedented quality is alarming enough without the most extreme available language. What the Trump screams threats as prosecutor exposes worst crimes ever presented in federal court framing ultimately captures is the accumulated Trump criminal accountability record. The 34-count conviction, the dismissed federal indictments, the Bedminster audio, the mountain of evidence, the screams and threats communication pattern, and the gag orders those threats have produced. That accumulated record is as historically alarming as the most dramatic language the headline can deploy. Not because it represents the physically worst crimes in the absolute federal record, but because it represents the most unprecedented criminal accountability and the most consequential accountability category in the American constitutional history. The screams are documented. The threats have produced formal judicial responses. The exposure is real and preserved in the unprecedented quality of the first American presidential conviction. The historical fact whose alarm the worst crimes ever language is most urgently trying to communicate is as consequential as any framing can accurately convey. The screams are documented in the gag orders that formal judicial authority required to constrain them. The exposure is documented in the indictments, the evidence descriptions, and the 34-count conviction. The worst crimes ever is the dramatic language whose most accurate application is the most historically unprecedented presidential accountability record in American history. Not the physically most alarming federal record, but the most consequential constitutional accountability in the most consequential accountability category that the American constitutional design most urgently requires to remain accountable through the formal legal mechanisms available to it. The first president convicted of a crime, the first former president federally indicted, the first person in the White House to face this combination of accountability cases. That's the accountability story, and it is as alarming as any framing of the worst crimes ever language can describe. The specific institutional determination that a sitting president cannot be prosecuted produced the without prejudice dismissal that preserved the federal charges rather than extinguishing them. The specific constitutional obstacle of the sitting presidency prevents the most serious federal charges from proceeding to trial while Trump serves. But the without prejudice designation means the charges can be refiled if the constitutional obstacle is removed. The exposure is preserved. The evidence is in the record. The Bedminster audio, the surveillance video, the Meadows testimony, the January 6th documentary record, all of it remains available for the specific future context in which the most serious federal charges can proceed to the trial, where the most damaging evidence would be most formally tested. The screams and threats that produced the gag orders, the ABA warnings about crossing dangerous lines, the formal judicial interventions, all of that is documented in the public record. Trump didn't literally scream in a courtroom. He screamed through Truth Social posts, press conferences, campaign rallies, and formal statements. He screamed through the specific public communication channels most available to him, and the judicial system responded with gag orders, warnings, and escalating consequences for violations. The screams and threats are as documented as any element of the accountability story. The accountability story is real. The prosecutorial exposure is real. The 34-count conviction is real. The federal charges, dismissed without prejudice but documented in extraordinary detail are real. The screams and threats documented in gag orders and ABA statements are real. The unprecedented quality of the first American presidential criminal conviction is real. The constitutional paradox of the most comprehensive criminal accountability record in presidential history being preserved but prevented from proceeding to trial is real. And the accountability significance of the specific rulings is as consequential as any framing can convey without requiring the most dramatic rhetorical extrapolation to establish its genuine importance. That's the full picture. The accumulated Trump criminal accountability record is genuinely unprecedented in American history. The prosecutorial exposure is real and documented. The screams and threats have produced formal judicial responses, and the worst crimes ever language, properly understood, communicates the unprecedented constitutional significance of what we're witnessing. Not the physically worst crimes in the federal record, but the most historically significant presidential accountability in the American constitutional record. That's the story, and it's as alarming as any framing can accurately convey.